Well, the use of recreational marijuana has been legal here in California for 5 years now, but a bill was just introduced that would make it more difficult for employers to punish employees for past drug use. Joining us now to talk more about this is Dale Geringer, Director of California NORML. Dale, great to have you on. Appreciate your time here. This bill is intended to prevent employees from using past evidence or evidence of past marijuana use to either deny someone a job or to terminate someone. How would this legislation limit what type of drug tests employers could use and when they could use them?
Well, basically, it disallows employers from using pre-employment drug screens for marijuana that are urine tests or hair tests, which don't actually detect whether you're under the influence of marijuana. These tests that are widely abused don't detect the active element in marijuana, which is called THC. They detect something else, a so-called metabolite of marijuana that has no effect on you, doesn't make you high, and stays in your body for days and weeks after last use. So these drug tests, the urine tests for marijuana that are being widely used, are really interfere on employees' right to do what is legal under California law while they are not on the job. Our bill does not affect the ability of employers to test for actual impairment by looking for THC,
Right,
like in your blood or something like that when you have an accident or when you're on the job. They just affect these tests that don't detect impairment.
So how often would you say that employees in California are facing repercussions of in some form or another based on urine or hair tests that have shown, that show the past use of marijuana? What were the figures that led to this legislation? Sorry, go ahead,
I think
please.
it's over 40% or 50%, over 50% of corporations in America now regularly drug test using urine tests for marijuana or all their employees for pre-employment screens. That's where this abuse is going on the worst. And they'll even, in fact, they will discriminate against you if you even say that you use marijuana, or admit to that. That's a legal grounds for dismissing somebody in California. You cannot be dismissed under California law for doing other legal things off the job. For example, you can drink alcohol, you can smoke cigarettes, you can fire your guns or whatever if it's off the job. But for marijuana, the courts have ruled that you can't, even if you're using it for medical purposes. So this is really an unfair law that has needed correction for a long time.
Finally, Dale, just one last point to hit on. This bill, I understand, would have certain exemptions for employers built in, allowing them to test for THC using a blood or a urine test in certain situations. Is that right? What would those situations be?
Well, if you're subject to federal regulations that require you to conduct the drug testing, obviously we're not doing it. There may be some other industries or jobs that have specific regulatory or other requirements that will need exemptions as well. So we're still working on that. It will be a while before this bill is actually finalized.
Yeah, that's what it sounds like. Could be a couple of years before things are nailed down precisely. Appreciate you coming on to talk about some of the framework for this bill that's in place right now. Dale Geringer, Director of California NORML. Thanks for your time.
Thank you.